All right, so welcome. Thank you all for coming. Really appreciate it. We want to go ahead and get started. We've only got an hour for this debate, so we want to make sure there's plenty of time for questions. Hopefully we can start on time here. So my name is Gregg. I'm a telecom policy analyst at the Information Technology and Innovation Foundation. So we at ITIF are a nonpartisan, nonprofit think tank focused on issues surrounding innovation policy. So the topic for today's debate, net neutrality, of course, needs no introduction itself. I think by my calculations, this is about year 10 we've been talking about net neutrality. Maybe this debate will finally put it all to rest. But I do want to run through very quickly, introduce all of our panelists. We've got longer bios available online, so I was just going to very briefly run through who people are and where they're from. So the general format, we're going to start with opening statements, running down, starting with Michael Weinberg, who's Vice President of Public Knowledge. Then you'll be forced to listen to another 5 minutes of me, Gregg from ITIF. And then next we'll have Engstrom, who's a Policy Director at Advocacy. And batting cleanup will be Gregg Rothschild, Managing Director at the Global Park Group. So keeping us all in line will be Barb Gallo. He is Managing Editor at Bloomberg B&A Telecom Law Center. I've given him authority to cut us off, to throw a shoe at us or something if anyone goes over time, so you ready for that? So after opening statements, we're just going to move very quickly into questions. First, questions from Paul, and then we're hoping to have plenty of questions from the audience, so keep that in mind as we're running through our opening statements. And one last housekeeping matter, we'll be using hashtag net neutrality, so that'll be picked up with a broader conversation, so feel free to engage that way through Twitter. So without further ado, I'll turn it over to Michael for the statement.
Thank you so much for having me, and yes, thank you all for coming to another panel on net neutrality. Hopefully we're moving toward the end of this season of net neutrality. It'll be a while before the hiatus ends and we move to the next one. Because I know that a lot has been said and a lot remains to be said about net neutrality, what I wanted to do right now was just sort of go back to first principles a little bit and give everyone a sense of why organizations like mine, I work with an organization called Public Knowledge, public interest, nonprofit organization, why we are pushing so hard for strong net neutrality rules and why we think those rules need to be grounded the way that we do. So just from a fundamental standpoint, what are we talking about when we're talking about the internet? We're talking about rules that prevent ISPs, those companies that connect to the internet, from influencing what succeeds or fails online. Your ISP has an important job to connect you to the internet, go to the services, the sites, the places that you want. And that's critical, but what you don't want to do is put that ISP in a position to be a gatekeeper to say, well, this site is going to work better than that one. Maybe we're going to prioritize or deprioritize various services. And so what that does is it creates a really level playing field. And Evan, I know, is going to talk about level playing field from just a commercial innovative standpoint. Those things are really important. But what it also does is it creates this opportunity, this space to create new opportunities, new communities, new places for people to come together in ways that are often very unexpected. I think we all have these places online that, yeah, sure, we all use, we all use Google, we all use various services. They're going to go to the New York Times, go to Politico, but that everyone has their kind of their own private internet that grew up in the shadows, is not high profile, is not going to be represented in Washington, and it's sort of your passionate corner. And the reason in most cases that corner exists is not because they were VC funded or there was a great startup idea that got Kickstarter or whatever it was. It's just that there was a group of people that came together and said, this platform is a place that we can find each other and we can do the thing we care about. And that sometimes gets lost in the larger conversations about various edge providers and large companies. And so while those things are incredibly important, we'll talk about them a lot today, it's worth keeping in mind that other part of the internet, often the non-commercial part of the internet, although it can be commercial, that makes it an important place for you as an individual. But what does this mean when you talk about rules, you talk about authority and all these legal things? I mean, fundamentally, what we're talking about are rules that say to ISPs, no blocking, no discriminating. You don't get to choose if something works better or worse, whether for love or money or whatever other motivation. I don't care what you think about various websites. I don't care if you want a commercial relationship. What I'm paying you to do is to connect you to the sites that I want you to connect. And when you're talking about rules that are those clear, right-line rules that govern connectivity, one of the questions you need to ask yourself is, okay, we're going to have these rules, and the FCC is going to implement these rules. What authority are they relying on? And this isn't an academic question. I sort of wish it was an academic question. It might make life a little bit easier. But what we have learned through court cases, through some would argue trial and error, is that there are some authorities that the FCC can rely on that are compatible with strong open internet rules, and there are some authorities that aren't. So we advocate very strongly for Title II authority for open internet rules, not because I get a royalty every time I say Title II, or I've joined some sort of cult that promises me great gifts when we say Title II, but because Title II is the only means to the end, and the end that we care about is a free and open internet that is protected from interference by ISPs. And so again, when we're thinking about these issues, it's sometimes helpful to go from first principles of an open internet, a level playing field, a place for people to do basically what they want without interference. Think about what those rules are: strong no blocking, no non-discrimination rules, and then think about the authority that is necessary to get there. And for us, that's Title II authority.
So, with this opening statement, I'm hoping to make three general high-level points. First of all, this debate over net neutrality is much narrower than many of them like to believe. Second, some regulated discrimination on the internet is a good thing. And three, that Chairman Wheeler's original 706 proposal is a very thoughtful approach that we should consider returning to. So first of all, this debate in front of the FCC is much narrower than many have been led to believe. This is not about being for or against net neutrality. All of the high-level principles that Michael laid out, I'm in full agreement with. This is a narrow question over the jurisdiction the FCC uses to implement those high-level principles. So we have two general options here. Option one is continue to regulate broadband as an information service using Section 706 of the Communications Act. Option two is classified broadband as a Title II telecommunications service. So under option one, this jurisdiction was clarified with the Verizon decision in January, where the court vacated the 2010 net neutrality rules. And it shows that the FCC has broad authority to prohibit practices that impinge on the virtuous cycle. So this virtuous cycle is the feedback loop whereby innovation on the edge drives consumer demand for further broadband upgrades. So the FCC has authority to step in anytime any sort of business arrangement threatens that virtuous cycle, that feedback loop. However, it allows commercially reasonable arrangements as decided on a case-by-case basis. So option number two, classifying broadband as a Title II telecommunications service. These rules are designed for micromanaging competition for what was a monopoly telephone system. On the narrow issue of net neutrality, it simply bans unjust and unreasonable discrimination. A lot of the problems with Title II come with all the baggage and uncertainty of other aspects of that classification as a telecommunications service. And furthermore, it's well established that under Title II, we cannot ban all forms of discrimination. Even with a plain old telephone system that the Title II is designed for, you can do both discounting wholesale traffic, you can do the equivalent of sending party pays, think like a 1-800 number, you can charge more for premium services, think like a 1-900 number, among all sorts of other forms of discrimination, all of which are allowed for a very good reason. So it's not clear to me what we gain by going the Title II over 706. So big point number two, some forms of discrimination are absolutely good for the internet. I'm in agreement with Michael. We do not want to see any blocking. We do not want to see any gatekeepers. We don't want any sort of degradation of traffic. That's not what this debate is about. These are not real fears. There's no no ISP out there who has any interest in blocking any sort of traffic and degrading any type of application. And furthermore, there's no way that any of these practices would be considered commercially reasonable under the rules of 706. A major important point that I think is often lost in the net neutrality debates today is that not all bits are equal. The internet is not one application like the circuit switch telephone network. There are a wide range of different sorts of applications and all rely on different types of network metrics to determine whether or not they succeed or fail. Two important metrics that I think have largely been lost over this debate over fast lanes, in addition to throughput, are latency and jitter. So a fair way to think about this is no one really rightly cares whether or not their email arrives 100 milliseconds late. But if packets in a voice over internet protocol call are more than 100 milliseconds late, the service is virtually unusable. So this application diversity will only increase with time as we move forward, looking at more cloud-based, real-time applications. And I think that this is the real advantage to Section 706, is it allows flexibility in looking at potential real-time applications that would need prioritization in order to succeed given the current internet architecture. The third point, I think Wheeler's original 706 proposal is a thoughtful, legally well-supported approach. His proposed rules would give the Commission effective tools to police this space and follow the clear jurisdiction laid out in the Verizon decision. Given the lack of actual net neutrality violations to date, and considering we have been able to clear up even alleged violations without rules, drastic measures with serious unintended consequences are really not warranted. Thank you.
Hi, I'm Evan Engstrom. I'm from Engine Advocacy. It's an advocacy organization that represents community of technology startups. So companies that are small, companies that don't have a lobbying staff, companies that don't have attorneys. Essentially companies that cannot afford to operate in a world where they have to challenge commercially reasonable priority deals, where they have to hire staff to negotiate these deals. Companies for whom milliseconds of latency is a matter of survival or not. Studies have shown that any amount of latency in differential speeds, basically, between various websites results in a pretty big drop-off in usage. So this isn't like a larger company like Netflix, where if you have to wait for that video to load, you're going to come back next week and say, okay, I'll try it again. Small companies, they have one shot to get you, and if there's poor operation, the user's going to blame that on the company, not the ISP, they're going to move on. So it's important to make sure we understand the stakes of this debate. It's great that we can talk about big principles, that we agree on certain aspects of this. It's great that we agree that blocking is just inappropriate across the board. It shouldn't happen. We would argue that throttling and paid prioritization are just as bad. And there's evidence to show that this is really a big problem. I mean, Comcast, one of the reasons we got into this debate back in the day was Comcast was throttling BitTorrent traffic. They made the decision to throttle and not block because that makes it look like the problem is with BitTorrent, not with Comcast. So we really want to understand that this idea that paid prioritization is fine, there are useful applications for it, really I think is a dangerous path to go down. Startups simply cannot afford paid prioritization, both as a matter of competition and as a matter of navigating that space. As one of the few attorneys working on behalf of startups out there, I can tell you that the staffs they have don't include people like me. It's engineers, it's programmers, it's people, if the average startup raises $80,000, that's a drop in the bucket. That's not going to be able to run these deals. It's not going to be able to afford navigating the legal mechanisms that you have to go through the challenges. So a rule that allows discrimination is really no rule at all from the startup perspective. And now let's consider why this is so important. Startups represent virtually all new net job growth in this country. These are people who are creating jobs. This is an ecosystem that has been tremendously successful for this country. And it's one that we don't want to turn our backs on. And it's important that I say turn our backs on, because let's not forget that net neutrality is the norm. It's the standard that has gotten the net to where it is. And it's the standard we should continue going forward. The debate we're having, people frame it as this is a radical departure from what we've done historically. It's different in terms of the authority that we use. What's the hook that gets us the rules we've always had, the rules that have always worked? From our perspective, the dangers of allowing things like prioritization and throttling are so great that we need to make sure the rules we put forward are ones that are going to protect that. I think the Verizon court made clear that absent reclassification, you cannot prevent these deals from happening. So I would also note one of the big myths that concerns us about net neutrality and the impact it has. This idea of differential speeds, dealing with things like latency and jitter. We want policies that promote speeds overall. The Verizon court itself said that this idea of the virtuous cycle, having an open internet that promotes deployment of these edge company resources and drives up interest in them, is going to promote development of new broadband technologies. They're going to promote investment. This is what we want. We want more speed. We don't want there to be a choice between how we slice up packets to make sure there's the least jitter. Policies of paid prioritization are simply policies that monetize scarcity. Instead of allowing an opportunity to monetize scarcity, we want to get rid of scarcity. And as the Verizon court said, as the commission said, open internet rules will do that. So we need to really think about the implications of what happens if we go away from this path. Quite frankly, based on everything we've seen from courts in the past, going down the 706 path is leaving net neutrality behind. And I think given this enormous success the internet has provided for startups, for companies around the world, leaving that standard, leaving that status quo is just dangerous and can't leave it up.
Thanks, and I think you just started three really terrific presentations. I'll do my best to kind of to try to match what you just heard in terms of clarity and brevity. So let me just start by saying, I think from a policy perspective, this isn't very complicated. We all really want the same thing. When I say we, I mean you all and we all as consumers, our families, our friends, policymakers, the FCC. We want a free and open internet. We want to be able to go up anywhere we want, unfettered access. And we want a lot of investment in the network. And we want a lot of investment at the edge of the network. In other words, we want the ISPs to continue to build stronger, faster, better broadband, deeper and deeper into America, wireline and wireless. And we want all the great companies, the ones that Evan represents, all the way up to the Facebooks and the Googles, to continue to invest in all their applications that we all enjoy. So I think one thing that's important to remember is that where we are now and where we've been since broadband has really come into being some 10, 12, 14 years ago, there have been net neutrality rules in place for really a very, very short period of that time. That's not to say there shouldn't be rules, because I think everyone here agrees that rules are probably a better thing, because you always have to police bad actors. But I think it's just important to understand that as a framework, because that kind of informs where we should go from here. And what I mean by that is, very simply, cable modem service, which has always been, I think, the leader in terms of subscribers in broadband, has never once been regulated under Title II. In other words, it was declared an integrated information service in 2002. That went to the Supreme Court affirmed, and it has always been regulated that way. It has never been regulated as a common carrier service. Wireline broadband, in other words, FiOS, UVerse, telco broadband, became an integrated information service in 2005, and in 2007, wireless the same. Now, we had a brief period from the time the Janikowski rules went into effect until the time where they were overturned by the Verizon decision last January, where there were those net neutrality principles. But I just think it's important to remember that all the Googles and the Facebooks and all the companies that Evan represents today, and Google and Facebook were once that size, they all came into being and grew and got investment without Title II in effect, without common carriage regulation being in effect. So I think we know that in the past dozen or so years, we have lost countless trees to the net neutrality debate, whether it's been comments filed with the FCC, whether it's been hearings and transcripts in Washington. And again, this is not to say that we don't need rules, but again, it's important to remember the actual state of the marketplace. There have been really a handful of net neutrality violations that have been documented. So, and I worked up here, and so we chaired, we held hearings as Democrats, and we were in charge. Republicans held plenty of hearings when they were in charge. No entrepreneur ever came to Washington and said, I couldn't get funding. I couldn't get funding because my investors were worried that I'd have trouble reaching consumers over an ISP. So with that as kind of for lack of a better word, a factual backdrop, where do you go from here? Well, twice the FCC tried to put forward net neutrality rules and justify them to the court. And each time it kind of threw spaghetti at the wall in terms of What are we going to use? What statutory authority will we use to back up these rules? And the court has looked skeptically at that and has thrown them out in the past. Now, what's interesting, what happened in January is the court said, over Verizon's objection, you, the FCC, have the authority to regulate broadband. You have the authority. It was the first time the court actually said to the FCC, we affirm your authority to regulate consumer broadband internet access service. And they said you can do that under Section 706 of the Act. So the FCC has very clear authority to regulate under 706. It's a question of what they can do and what they can't do. But they have very clear authority in that space. Now, I think it's a question, and what Wheeler was trying to propose is, let me take this out for a spin. I know I haven't. For the first time, the court said we haven't. So let me see what I can do with it, which is why I think he probably wanted to go down that road. Now, the other, and I think we'll probably talk more about Title II, but the reason that a lot of folks are scared of Title II is kind of twofold. On the one hand, ISPs know what Title II means. The telcos in particular lived under it for many, many years. Title II is literally thousands of pages of regulation over everything you do with your network. You want to price something, you want to build something, you want to take something down, you want to introduce a new service, you have to go to regulators. And once something's declared a Title II service, you not only have to go to federal regulators, very often the states get involved as well. That's the history of Title II. That's not an opinion, that is what Title II means. So the ISPs are very nervous about that. Because we've always had, for lack of a better word, a deal when we regulate monopolies. We say to the monopoly, we're going to regulate you, everything you do. We will regulate when you build, when you take down, when you invest, what you write down, how much you can raise your rates. But what we're going to do for you to make sure you can continue to invest is we're going to guarantee you a rate of return. That's how we regulate the electric companies today. That's how we used to regulate the phone companies. Well, the problem with kind of a Title II is that that bargain doesn't exist today. We want the ISPs to continue to invest tens of billions of dollars every year in broadband. But if we go to Title II, they'll have all the burdens of that regulation, but they won't have the incentive to invest. We typically give them monopolies, because they're not monopolies. So then that kind of goes to the question Doug was raising, do we really want to regulate them as such? So I'm sure we'll talk about forbearance and all the other pieces of that are part of that debate. I just wanted to kind of set the table in that manner to start.
Thank you all for those presentations. And my name is Paul Raviello. I'm an editor at Weinberg, and I'm honored to moderate today's panel. I thought we could take a step back for a moment to reframe the debate. Of course, today's panel discussion is about the legal framework. Which legal framework is best, Title II or Section 706? For those in the audience who might not be as versed on the issue, Title II under the Communications Act was written at a time of copper wire telephone networks. It was written to essentially protect consumers from the then telephone monopoly, AT&T. And as Gregg pointed out, there were thousands of pages of regulations that flowed from Title II. Title II itself, I believe, is about 45, 50 pages just in the statute. And of course, there are many titles. Wireless services are classified under Title III. And broadband internet access service has historically been classified as Title I information service and given like regulations. Cable services have been classified under Title VI. Just to give you a sense of how the statute was written, legislators for a time were very concerned about the effect of consumer, and they felt that these services should be regulated differently under different titles, different buckets. And over time, those buckets meant less to the consumer. I think we can all agree, no matter where we stand on the issue, that the distinctions might not make as much sense to Congress, to the FCC, and to consumers. Title II has a lot of very interesting aspects that could help certainly net neutrality, bring about net neutrality. And just to kind of take another step back, what FCC Chairman Tom Wheeler has suggested is that we can reclassify broadband internet access service under Title II as a common carrier telecommunications service and forbear from applying the entirety of Title II except for essentially 6 provisions. Section 201, which would require internet providers to interconnect and charge reasonable rates. Section 202, which prevents price and service discrimination. Section 208, it sets up an FCC complaint process. 222 protects customer privacy and proprietary commercial information. 254 allows the universal service fund for broadband. 255 ensures disability access. So certainly, within Title II, I think we can all agree that there are certainly provisions in Title II that can get the FCC to where it wants to be. Conversely, you have Section 706, which for the first time the DC Circuit Court earlier this year said can provide a source of authority for the FCC to regulate ISP's behavior, regulate web traffic. And just to kind of give you a sense of what 706 was, 706 was a section of the 1996 Telecommunications Act, and there are essentially two parts, A and B. And A said this: we direct the FCC to, quote, encourage the deployment on a reasonable and timely basis of advanced telecommunications capability for all Americans by utilizing in a manner consistent with the public interest, convenience, and necessity, price cap regulation, regulatory forbearance, measures that promote competition in the local telecommunications market, or other regulating methods that remove barriers to infrastructure investment. Now, B requires the FCC to, quote, determine whether advanced telecommunications capability is being deployed to all Americans in a reasonable, timely fashion, and take immediate action to accelerate deployment of such capability by removing barriers to infrastructure investment and by promoting competition in the telecommunications market. So I apologize to you all if you're familiar with that, but I just thought it would be helpful to put both up for you. We tend to throw around a lot of terms in the debate, Title II, Section 706, and of course, these are essentially the two sources of authority that the FCC can draw upon. And of course, the President came out this week and said, FCC, please reclassify broadband under Title II. So with that setup, starting with Mike, talk about which approach, from your perspective, can withstand the most legal scrutiny. Because, of course, no matter what the FCC does here, you would say somebody will
guarantee. Yeah, I think the honest answer is that they can both withstand legal scrutiny. And it depends on what the rules are. And looking at the DC Circuit opinion, it set up some pretty clear guidelines. What the DC Circuit essentially said when they overturned the 2010 rules the last go of this was, okay, FCC, you declined to classify broadband internet access as a telecommunications service, and therefore you cannot try and apply common carrier style rules. And so the FCC essentially has a choice now. If they are interested in bright line rules that are categorical rules that say you cannot block, you cannot discriminate, they have to reclassify broadband internet access under Title II as a telecommunications service. If instead they would prefer to have rules, as was in the Chairman Lewis's proposal in the spring, that say, generally you can't block, but we will test all of these, we're going to leave room for negotiation, and if it's commercially reasonable, which we'll use a 12, 16 factor test for, then it'll be okay, we'll have a nice long process for resolving these. Then you can go under 706. And that's the kind of rule that is sustainable under 706. I agree, I think that the proposal in the spring was very well layered, and it was the best proposal that you could have under 706. And the reason that so many people from a number of different communities and industries completely freaked out was because it didn't really come with bright line rules that would actually prevent the harm that we're talking about when we talk about protecting the internet. And so the reason, again, I wish if you could do real open internet rules under 706, my God, we would be done with this conference. We would be talking about something else.
it would be so much easier. But I think the reality, as described on the DC Circuit, is to do real net neutrality rules, you have to go for Title II. If you want them to be sustained from the challenge, that's the path you have to go down. But it all comes back to the choice. I mean, if you don't want real net neutrality rules, then yeah, you can go. That's what 706 is. We're the order to do it.
Doug, did the FCC use 706 and survive before China?
So I think so, absolutely. And not only that, I see 706 as being quite a bit stronger than Michael's characterized it. So as I said, he's absolutely right. The Commission cannot treat broadband providers as common carriers if they continue down 706. But I would say, as a matter of good policy, we do not want to treat them as common carriers. Rather, under 706, they have broad jurisdiction to step in wherever this virtuous cycle is impeded. And so I would contend we can get pretty narrow, pretty detailed, bright line rules under Section 706 as long as we leave open these narrow types of individually negotiated commercial arrangements. And so if we want bright line rules, there's been a lot of concern raised mainly about types of privatization. Almost always in public debate has been focused only on privatization that focuses on bandwidth, right? And so if we want to talk about something like bandwidth reservation, I would think that under 706, the Commission would be authorized to make bright line rules saying something to the extent of, like, only 15% of a consumer's bandwidth can be reserved for a particular application. Furthermore, that bandwidth can only be allocated on top of the amount of bandwidth the consumer already pays for. I would say that this would be a good way to allow for commercial arrangements. A bright line rule does not do anything to impact the open internet or degrade any of the services that are continue to flow under the amount of bandwidth that a consumer has already purchased. So I think that there's plenty of room to create real bright line rules that continue to allow the open internet to flourish under 706. And I think it's legally sustainable that as long as we don't treat them as common carriers, shut down any type of commercial arrangement, then it's clearly legally sustainable under the present position.
And because of the opening remarks that the judge, in his opinion, in the Verizon case, basically said, you need to classify, otherwise rules might not survive another challenge.
Yeah, no, I think that's pretty clear. I mean, as far as I read it, the Verizon court stands for two big propositions. Number one, open internet policies are good for the innovation economy. And number two, you can't have them unless you have Title II. So any debate about whether we can have actual net neutrality in some other format without going down the Title II path, I think it's an empty promise. I would also note, I mean, whether or not, in this whole debate about whether things can survive scrutiny, number one, the one thing that we know can survive scrutiny is nothing, but that's not what we want. Number two, a lot of people have looked foolish trying to predict what the DC Circuit Court is going to do. So it's always going to be a lot of tea leaf reading, but they really made it clear what needs to happen. So any type of plan that would take priority, and rules against paid privatization seriously require Title II. And as I've said before, that this is not an idle threat. I don't understand why we want to allow paid prioritization. If one of the arguments for avoiding Title II is because, well, we've never had it, and look, nobody's been discriminating so far. To me, that's a reason to make sure that people don't discriminate in the future. If we didn't have discrimination and it worked really, really great, why would we start allowing it? When we know that that's going to cause problems, and we know that speed differentials have impacts on consumers. So it's a very bizarre set of inferences you have to draw to come up with this idea that, well, we should have prioritization. It isn't going to cause a problem because a lack of a rule against prioritization, that's bizarre. So all that to say, yeah, I think the court was strangely corrupt. This is what has to happen if we want real rules.
Yeah, I hate to be a buzzkill. That's not exactly what the court really said in the Verizon decision. But I think that, so let me deal with that. Let's also talk about Title II, because that's really, the president called for it. It was really kind of interesting. I mean, for the life of me, I've been doing this for far, far too long, and I've never seen a president really tell the FCC what it needs to do on an issue, and I thought that was just kind of interesting. But putting that aside, it was interesting with how the FCC reacted. So the president said you need to do Title II, and here's why, and free open the internet, and of course that's what we all want. And then Wheeler put out a statement about an hour later, And the most interesting part of that statement was the second to last paragraph, where he said, and I'm paraphrasing here because I forgot to bring the statement, but he said something along the lines of, you know, that's going to be really tough. There's actually a lot of problems with going down this Title II road. There's reclassifying wireless and forbearance and a lot of legal complexities. And I encourage everyone, so there it is. So the more deeply we examine the issues around the various legal options, the more it's become plain there is more work to do. Reclassification before us raised substantial legal questions. More time to examine these and ensure the approaches taken can withstand legal challenges. Policy issue, privacy, universal service, protect consumers, cover mobile, concept of applying forbearance. This was a Democratic chairman of the FCC just saying, wait a second. The reason he said, wait a second, is in this debate sometimes you get the impression that the president of the FCC can kind of wave their wand and say, poof, your Title II services. You really can't do that. The reason you really can't do that is, and if you go back and read the FCC decisions, and I don't encourage anyone to actually go back and read these FCC decisions, but the 2005 and the 2007 decision in particular, where Democrats concurred, and the 2007 decision on wireless happened for a pretty specific reason. The FCC has to follow the statute. And in the 1996 Act, the statute defined telecommunication service, which were to be common carrier services, which is essentially sending information from one point to another without any change in the form of the information, a telephone call. And also, it took what was largely how we saw what was dial-up internet access at the time. For those of you who have far exercised minds and remember dial-up internet access, it defined that as an information service. And as broadband was rolled out, the FCC pretty much said, you know, we can't sustain classifying broadband as a common carrier service. If it really falls outside of the statute, we're going to do this. And it wasn't some Republican plan. The Democrats concurred in those decisions. So I think that's one important point here, is that what the FCC does has to be consistent with the statute. The most interesting part of there is wireless, because this is a really kind of easy one. The statute defines two kinds of wireless services, commercial mobile wireless and private mobile wireless. Commercial mobile, which was voice wireless, is defined as something that connects to the public switch telephone network. And that essentially means the phone network that we all use when we make a voice call that's not Skype, an actual regular voice phone call. The statute says that's a common carrier service. The statute says that if it's not touching the public switch network, it's a private mobile service, and you can't regulate it as a common carrier. That's why the chairman said in his statement, you know, we might have some problems classifying wireless as a common carrier service. The problems probably aren't that stark when it comes to wireline, but they're still pretty difficult. So let's just put that aside as Title II and then talk about 706. I don't know exactly where 706 leads us. There's been one decision on it. It affirmed the FCC's ability to affirm the FCC's authority to regulate under 706. And it said you can't have pure common carrier regulations. That's what it said. It didn't say we're fine with Title II. It didn't say we affirm Title II. It just said you can't have regulations that read like common carrier. So what Wheeler wanted to do is basically say, okay, if I can't block, if I can't say no discrimination, let me say that you can't do certain things that are harmful to consumers or harmful to competition. I think that fits within 706. And if you read the roadmap that the Verizon court kind of laid out, because as we all know, courts tend to do that, after the court said you can't regulate non-common carrier services as common carriers, the next few pages go through, but here's how you can kind of get there without getting there. And that's what Wheeler was trying to do. So I think it's worth, at least from what I was saying, if you want legally sustainable rules that are probably settled pretty quickly for whatever it's worth, every major ISP said if you take a 706 approach, we will not bring an action in court. Now, why would they be suing to get rid of something that they've suggested the FCC take? It's a cheap shot to laugh at that, but that's candidly what they all said. Now, I guarantee you they'll all sue if it's Title II. I guess if it's 706, public knowledge could sue, but you'd be suing saying, we like that you regulated net neutrality, but we think you needed to regulate further. That's a much more difficult action to sustain legally. So again, from the perspective of we all want net neutrality rules, we all want rules of the road because there are going to be bad actors. And I don't think anyone here would disagree with that. Title II is a path that we may end up, and candidly, after the president spoke, I think that's where the FCC likely will end up. But I do think that is a much more perilous path forward, and that probably is going to end us back here with this hyper-exciting panel in another 4 years.
Well, you've heard a lot from us. Wanted to hear from you. Let's take a pause and take some questions from the audience. Anybody have a question?
What do you think is a better framework to bridge the digital divide?
By digital divide,
Some
lack
people already have
broadband
broadband
access.
or communities.
It's an interesting question. So, my understanding is that digital divide is largely not an issue without broadband build-out or broadband deployment. Setting aside the last few percentage that we have to reach for universal service, the vast majority of all communities are served by 2 or more wireline networks. And so I think it's hard to say that one approach, while one approach might encourage further investment and deployment, and one would, I'm not sure, it's a bit speculative to say how that would impact the digital divide. Absolutely a legitimate problem. A lot of it's around issues about interests and relevance. Some people don't believe that broadband is relevant to them. They have no interest in signing up, even though it's offered in their area. So it's hard to say which one would be better for the digital divide.
I have to say that we as a country made a decision a number of decades ago that everyone would get phone service. And there are also, there's multiple panels worth of conversations we could have about the universal service program, but it is a framework that fundamentally means that everyone in this country, no matter where they live, and I've got a brother who lives in upstate New York, he doesn't have good internet, but he's got a phone line. And so when you think about the Title II framework that allows us to do things like universal service, if you think about wanting to make sure that everyone has access to broadband, that's a path that is well trodden and we know it works. And so if you're thinking about what you want to do to make sure that we can close the digital divide, it seems like a good way to look at an imperfect one, but a useful one.
I would say the pivot answer is if you believe the FCC and the DC Circuit Court in their upholding of the virtuous cycle, then in open internet, if you want to drive demand for broadband, that's going to encourage deployment, and the better infrastructure we have, the better ecosystem we have, better service with better products, the more people are going to demand broadband.
Yeah, I think that's right. I guess it's hard to predict the future. I mean, the only thing I would say is that literally every company in America that builds broadband, or just about everyone that builds broadband, has said that we're very nervous about what a Title II environment will do to the economics surrounding the business. I think it's also worth saying that as smart and well-intentioned and candidly right, I'm sure, in a lot of things, the folks who are articulating Title II are, none of them are saying we will build broadband. So if the goal is to get broadband further and deeper, it's at least worth listening to the people who actually build it as to what their sense of what the right regulatory regime should be. Certainly, don't take everything they say at face value. Don't take anything anyone says in this town at face value. But certainly, I think it's worth, at the very least, giving it a due of respect, since they're the ones who are actually going to build it. And you can make what you want of AT&T's statement yesterday, but they said we are going to delay plans to build additional broadband high speed into 100 cities because we're really not sure about where the regulatory environment is headed right now.
I'm not from here, so you can take what I say, please.
Certainly.
Yeah, one of the kind of the primary arguments you hear against Title II is that the regulatory uncertainty and have potential for too much regulations and flash information, so we would be to support Title II will be your response to that.
I'll go first. I think that what do we know is going to hurt innovation? I would say, is probably the first question that I would ask. We know that discrimination is going to hurt innovation. If you have to pay more to reach customers, if you have to suffer with slower speeds relative to your well-heeled competitors, that's going to hurt innovation. Uncertainty hurts innovation. So we have to remember innovation at the edge. Edge providers have relied on a world where net neutrality was the de facto norm. Investors have relied on a world in which net neutrality was the de facto norm. Plenty of VCs have said, look, if we're going to operate in a world where we don't know whether or not an ISP can charge for preferential access, increase speeds dramatically for competitor services, their own services, we don't want to invest in these companies. Companies that are high bandwidth companies, frankly, high bandwidth companies are really the ones that are driving the economy pretty strongly right now. They're not going to invest in that. This idea that some unforeseen Title II regulations that frankly nobody really wants are going to inhibit investment in infrastructure, I think is unsupported. And I guess it's unclear what sort of innovation paid prioritization deals would entail. I don't think these schemes are innovative. They're gatekeeper access goals. It's not particularly innovative.
Yeah, I mean, I think that's a good answer. I think the one thing to remember also is that a lot of times when people are talking about regulatory uncertainty, they're talking about two types. Sometimes they say, well, this uncertainty will come because there will be lawsuits to challenge any Title II rules. And when someone is coming to you and saying, there will be regulatory uncertainty because I am going to sue, and they think uncertain, that's worth to you.
Now, in terms of the rules themselves, I mean, there's no reason that Title II rules cannot be as straightforward, bright-line rules as 706 rules. There's nothing kind of inherent to that part of the law that is special, that you can't be clear in a way you could be clear in 706.
There's so much said today, it's hard to know where to start, but I'll just ask one legal question. So the real Title II, you all have heard about the real net neutrality. The real Title II, as the chairman has pointed out, does not actually allow the FCC to ban paid prioritization across the board, because the essence of Title II, the essence of common carriage, has always been that you can charge a price for carrying traffic. So number one, can't ban paid prioritization. Want to hear your thoughts on that. Number two, as Larry Spiewak and others have pointed out, since the essence of common carriage is you charge everyone for terminating traffic, Title II would in fact authorize broadband providers to charge every single website, every single edge provider for carrying their traffic, which is a sender pays regime, which is the opposite of net neutrality. Furthermore, the argument that's made for forbearance, waving away whatever problems, that is difficult in general, but in this market, which the FCC claims, which public knowledge claims, is a terminating access monopoly, there is no precedent that would allow the FCC to forbear from those requirements in that market. So what am I missing? What's the real Title II, and how does it not get us to the opposite of net neutrality, let alone banning paid prioritization?
Thank you for the question, Bear. So, I mean, obviously, we disagree on the substance of a lot of this, and we've hashed out a lot of it. I think the one thing I want to focus on is this idea that Title, and we hear this a lot, that Title II does not, allows discrimination, allows differential pricing. And I think the answer to that is yes, it does. We are not saying that in Title II, once you reclassify as Title II, all of a sudden everything is done. The importance of Title II is not that it in and of itself gives us a free and open internet, gives us real net neutrality. The importance of Title II is that it allows the FCC to then come on and create bright line rules and say these things are allowed, these things are not allowed. These things, some activities are categorically unjust and unreasonable, and so we're going to bar them. And so, yeah, I mean, I think to the extent that people are hearing advocates push for Title II and think that that is somehow self-executing in the end of the conversation, that's not quite what we're saying. I think the importance of Title II, that I sort of alluded to this at the beginning, it's not really an end.
in and of itself. It enables a lot of things, and I think there's a lot of upside to it. But the reason that we care about it, and I'm going to speak for only public knowledge here, but I think that we're not alone. The reason we care about Title II is because it is an effective means to those fundamental ends that we care about. Not that it's in and of itself a goal.
And I would just quickly note that, I mean, what do we know? We know 706 cannot support strong net neutrality rules. That's abundantly clear. It necessarily allows for discrimination. There's no question there.
It allows for tightly regulated discrimination.
It allows for a 16-factor test that nobody who would get hurt by that is ever going to be able to challenge. So it's,
I mean, would your company use that process?
they wouldn't even know where to begin.
Just to bring the conversation to earth for a minute, the core, I mean, these are important things as we kind of move forward in this debate. First of all, as Michael just said, Title II does not allow anyone to ban discrimination or paid prioritization. So it's important to remember, it only allows for, it only makes illegal essentially unfair, unjust discrimination, which is something that would need a test anyhow that the FCC would have to rule on. So that's just, the other thing we need to talk about is this kind of notion of paid prioritization. I'd ask anyone in this room who has subscribed or has been offered or wanted to sign up for a paid prioritization service to raise your hand. You're all broadband customers. None of you, as far as I know, are signing up for paid prioritization because it doesn't exist in the marketplace. And the reason it doesn't exist in the marketplace is because the ISPs, who we all agree, are looking to increase their revenues, have not really figured out a way to make it happen. In fact, they've all said, I shouldn't say they've all said, just about all of them have said, we have no intention of doing this. So
Verizon told the DC Circuit that but for those rules, they would be exploring those deals. I've seen AT&T talk to people about offering sponsors.
So just to be clear, Verizon's general counsel just wrote a blog saying, we don't plan to do this, we have no intention of doing this.
Take backs.
It's not a take back.
What is it?
I'm very happy to say, so there are very different forms that you can imagine deals would take. So one form that could be paid prioritization would be the sender that you sign up for a system like a 1-800 number, which Doug talked about. So you decide you want to use a high bandwidth system. It's a gaming system. It's a startup. It's one of Evan's startups that wants to get market share. So it agrees to pay for your bandwidth. That's something that ISPs might want to explore, that they're very nervous they won't be able to explore in a Title II regime. The notion that Verizon would say, I will give you faster treatment on my network, is something that I would be shocked that they would, listen, I don't know, I'm not part of the company, but I can't imagine. They've had years and years of the ability to do that. There have been virtually no net neutrality rules in place governing these companies except for the short time of the Janikowski rules, and they've never done it. I can't predict the future, but it hasn't happened in the past. So I just think you have to kind of keep those truths in mind when we talk about what may or may not happen.
Another very quick point. I'm worried about potential future applications that are extremely sensitive to latency, jitter, other metrics like that, startup time. There are all sorts of different metrics that potential real-time applications could be very concerned about. So I worry more that if we try to go this approach of trying to get everything, all forms of discrimination and per se banned in Title II, it will end up locking down this network under how we understand it today, the particular applications that work well for it today, and don't leave room for potential innovation down the road.
I guess the quick response to that is we want to make sure we don't live in a world where latency is a problem. By having open-ended rules, as the DC Circuit and the FCC said, that's going to promote investment in technologies, in broadband technologies that latency is not even an issue.
Taking over-provisioned latency away. I mean, this is not a question of investment. This is a totally different metric than throughput.
As to Gregg's other point about it, we haven't seen these things in the past. I would say, first, however you feel about the Netflix interconnection dispute, the fact that there was a payment to get faster speeds is a short step away from the type of paid priority deals we're talking about. And I really just don't think taking profit-seeking enterprises' word that they're not going to do this stuff as a good reason to do it.
So just so we're clear, I agree with everything you just said. No one here is advocating nothing. There is the Title II approach, which I think has significant unintended consequences, and there is a 706 approach, approach, which has far less. So given that, which I think is undeniable, then if there were enormous net neutrality problems in the marketplace today, then one might argue you need to take very drastic measures to stop them. Given the state of the marketplace that there is today, given the enormous investment we've seen over the past dozen years in both the edge and in the network, taking the drastic measure of going back to monopoly regulation, which has never governed this marketplace, it just seems like it's not warranted.
Yes, sir.
Quick question. I'm curious to know what the panel's thoughts are on efforts for local broadband municipalization, how that impacts the net neutrality.
Municipal broadband.
Yeah,
Sorry, you mean municipal broadband efforts?
Correct, yeah.
I think they're great. I would note that there is some evidence from other countries, namely like Britain, where they have open access retail networks, that discrimination still doesn't occur when there's competition. That the market forces that are discipline certain monopoly activities by having multiple different providers available don't necessarily obviate the concerns we have, because whether you have 2 or 3 or 4 or 10 different broadband options, you still really only have one that you use. So there's a terminating access monopoly, whether or not there's a monopoly over the market itself. So while it's great and it does things like help encourage incumbents to increase speeds, the gatekeeper concern still remains. There's always going to be high switching costs, and even with transparency rules, I mean, I don't read my Apple care agreement. I'm not going to read the throttling reports. So it's hard to believe that increasing transparency is necessarily going to discipline that market failure concern.
So I think the question points to some really interesting facts. Like putting aside the sort of more political questions about municipal broadband, there are a number of projects going on now looking at Wi-Fi mesh networks as a potential way to connect communities. And every single one of those Wi-Fi mesh networks introduces a number of different hops within the network, right? And so this is where all those different hops drastically impact the existence of applications. So this is a huge concern. A number of these projects are looking at developing new protocols to route traffic through other wireless mesh networks that absolutely prioritize traffic, that this is necessary as a network management tactic in order to have a wireless mesh network function for a great deal of applications as it is today. And so I think the fact that, putting aside questions about broadband municipal networks generally, the fact that community-owned mesh networks are absolutely required to do network management, including prioritization of voice traffic, is very telling. That this is not like a big policy debate, but this is actually, as an engineering matter, necessary for some applications to succeed.
We have time for one more question.
First, I want to thank all of you. I think that you've brought a lot of light to a debate that often is about rhetoric and emotional passions. I want to thank you. And in this light, I did want to raise one other issue that is very important that hasn't come up. And that is the issue of what is this going to mean for jobs. And Evan, I'm going to send you back to actually look at the employment of the companies that you represent, because I have. And some of these well-known, very small startups employ maybe a dozen people, 2 dozen people, 3 dozen people. Even the very large application companies, when you look at their employment numbers and then try and figure out how many of them are programmers overseas as opposed to here, this is not the job creation engine that is going to resolve the deep problem we have of being in a recovery that is only feeding a very small minority of our population. Which the job growth isn't from startups. The job growth is home health care workers and security guards and janitors. But there is an area of good jobs that is very much about building, maintaining, and servicing these networks. And policies that tilt in favor of the generation of the revenue going toward the application and the service companies, and a minority and basically a lot of billionaire startups building and growing and servicing and maintaining the network. I think that there's problems there. And when you look at the data on the virtuous cycle that you've been talking about, there has been growth on both sides of that cycle. But again, the substantial investment, the billions, tens of billions of dollars that translates into good middle-class jobs with benefits for people is very much on the infrastructure side.
Very quickly.
Yeah, I would say there are, the first thing to consider is when we talk about startups creating jobs, a lot of that is not the startup of 5 people, it's the startup of 5 people that becomes the startup that employs 100,000 people. There are a lot of big name companies that began as startups that might have had a problem becoming where they are, if not for the openness of the internet. That's the great promise of the internet, is with $80,000, you can build a company that employs hundreds of thousands of people. As to the point about whether the infrastructure jobs are greater or how numerous they are, I would say that I don't believe that net neutrality principles diminish those jobs. We want to increase broadband build-out, and we think that having a rich application layer that encourages people to want broadband access will encourage people to build broadband. And as I said before, I mean, the idea of paid prioritization is really one of trying to profit off of scarcity. We want to get rid of scarcity, and if you allow people to monetize scarcity, there's going to be less incentive to build more to get rid of that concern.
We go over our time. Panelists, 30 seconds, final thoughts for the audience.
Sure, I'll just say that I think we all here are glad to hear we all agree we want an open internet. I think that there's a reason that we are fighting about the details, because the details matter. And the reason that all the public interest groups, all the startups, the 4 million people who waited with the FCC has said the details matter and we need Title II is because Title II is the only route to that real open internet that we all care about. Life would be easier if it wasn't true, but unfortunately it appears to be the case that it is true. And that's why these strong rules around Title II are so important.
So, just a broad point, I really have to say I object to the notion that this sort of more flexible net neutrality will allow for making profit off of scarcity. I really don't think this is what it's about. Again, this goes back to the point that different applications have different needs, and some of those needs are not met by the current internet architecture as it stands now. If we're able to change that, and people are willing to pay in order to do so, I think we should allow the flexibility to allow those sorts of deals to go forward. Again, these 706 would allow for very strong rules against blocking against sorts of discrimination and harm that sort of virtuous cycle of innovation and investment. And so I think that allowing flexibility and giving the FCC the tools, also maintaining the jurisdiction of the FTC over broadband providers would be a very important advantage of 706. I think that it's very clear in my mind that it's the correct approach to go.
I think that what we have to keep in mind here, the great promise of the internet is anyone with a small amount of money can start a company that becomes huge. If we make that more expensive to start a company, you're going to see a lot less innovation. You're going to see a lot fewer companies that become huge. I would love it if a commercially reasonable standard under 706 would work to protect people who are going to be hurt by this increased cost and the resulting lack of innovation. The reality of it is the companies I represent can't operate in that world. They don't have the resources. They don't have the staff. Title II, we believe, presents the clearest option to maintain the net neutrality principles that we've had for so long, and that's caused the internet to thrive.
Yeah, I looked at the title as I was walking in here, Title II verse 706. So God bless you all for coming. I thought my colleagues here on the panel were really terrific. I don't think about the same. We're happy to sit around that afterwards.
Well, if I could make one final comment, I thank you all for joining us. The FCC is a creature of Congress, and sometimes in the rhetoric, we lose sight of that, but the FCC was created by Congress, is a creature of Congress. And one of the reasons the FCC finds itself in the position it's in today is because Congress has never spoken explicitly about this issue. So if there's a message I can leave you with is that Congress really needs to make itself known in this debate. with that, thank you so much for joining us.